We've been very busy the last 2, 3 weeks, but I always say if you're not feeling it, don't get discouraged because for us, we cover all price points, from $400,000 to, major deals, everything in between, Brooklyn, Manhattan, Queens. So I know a lot of brokers, like to concentrate in many areas, but typically you have a niche, right? So your niche might not be as active, but we run our numbers every week. A great stat that I saw. Um, this last week we had a lot more non-contingent deals than normal. The reason that's exciting is because it means, people are financing, but it also shows there's competition, which forces people to go non-contingent, right? Obviously, your client has to be flexible and comfortable going non-contingent. We don't want to push clients non-contingent if they're not comfortable. And it really takes you as a broker being proactive and teaching them and getting them on the phone with an attorney and a banker. But the idea that we're seeing, more financing than cash, it's flip-flopped. For 2 years it was all cash deals. Cash is great, means quick closings, but it's not good. It's not a balanced market, right? So we want balance in the market, and that's what we're seeing. Um, and we're seeing, multiple contracts go out. We're seeing more competition. So things are definitely trending in the right direction. Um, but let's jump on to the topic at hand. Appreciate everybody, on for all those who just hopped on. I apologize for being in the car. This is not intentional. I had a calendar flop, and my first grade son, I have 4 kids, at a chorus concert today, and I made a mistake. So I wanted to obviously make sure I didn't miss that chorus concert. Um, so we're here. So I think like the big idea, just to make it as simple as possible. If you only learn one or two things today, because we're going to go a little deep because we want to teach you and give you, the value. But your idea is really issue spotting, right? Um, I'll like start with like the best piece of advice. If you are working with an international buyer, typically, and Chris will go more into this, and I'll introduce Chris in a minute. Typically, international buyers do not want to buy on their individual name because they could be subject to estate tax, death tax of up to 40%, and FIRPTA, right? FIRPTA is a withholding. Very important. FIRPTA is a withholding. It's not a tax. So think about this. You have a client that owns a property, right? And they're from Brazil and they own one property in New York. They have no other asset, no other connection to New York. They sell that property for $1 million gain. The IRS, the United States government, wants to make sure they collect capital gains tax, right? So if say they don't live here, or even if they do live here, they sell, how is the government going to get those funds unless they hold back money, withholding as security in order to get those funds? So if you're an international buyer, you're starting to speak to an international buyer, you're going to start looking at apartments. A great way to add value is to say, hey, listen, it's my understanding, I was on a Zoom call with an attorney, that if you're an international purchaser, you may, or most likely you will not want to buy in your individual name because you could be subject to estate tax or this FIRPTA concept, and it can all be avoided by setting up different structures. So I always say, if you refer me a client and I speak to them for 10, 15 minutes, we're off to the races. This conversation is a bit more detailed. It's not one size fits all, and Chris has to have a consultation. So listen, especially when you're in competition with another broker, adding that little note should definitely set you apart. And you want to set the clients up early because again, we have to see where they're from, what their assets are, if they have a team in New York, just to discuss the different options. So you're always going to say, hey, listen, it's just like speaking to a banker, right? Hopefully you're not introducing your clients to a banker right before they put an offer. When you meet them, it may take a few weeks or a few months to find the place you love. It's highly recommended that you just broach this subject. Hey, you're obviously an international client. There's estate tax. There's FIRPTA. Let's get you on the phone with an attorney that specializes in work with international clients just to start brainstorming about how you want to take ownership because we can avoid all of this if you want, most likely. I obviously go through the real estate portion, and Chris goes through the estate planning portion. And just some practical ideas, what we see, and we are definitely getting in the last month more international calls. International clients, we'll go through some subtle, ideas at the end, but it's a different cadence, obviously. We're all over WhatsApp with those clients. The speed, that's why it's really important, even for me, I think, to speak to a client about the real estate portion earlier on than, say, a domestic client because I'll explain the timing, I'll explain what due diligence is, I'll explain what goes into the contract, even the idea of putting 10% down. Basically, more information, the better without overwhelming them. As seasoned real estate professionals, where we understand what information to provide and what information not to provide. Again, not to overwhelm anybody, but they need to understand, like, if the money's out of the country and they have to liquidate assets, that could take a few days, a few weeks, sometimes. Um, so normally the cadence is, I'll discuss the real estate portion and Chris will discuss the estate planning portion. So good segue for Chris. Chris is a trust and estates attorney. So he works on with domestic clients, setting up, your trusts, your corporate structures as well. I say one of our claims to fame, we did a deal at 220 Central Park South. It was all over the newspapers. It was in Cranes, and not to be a real estate dork, but my most proud moment, the article's title said "Mystery Buyer Purchases $82 million apartment." We set up that part. We were able, and we can't always guarantee it. It really starts, with you guys, but we were able to set up a structure for a domestic client where there's complete anonymity. But Chris obviously also works with international clients. And it's a lot of just kind of discussion up front and consultation. So it's a team effort for sure. Um, but I'll hand it over to Chris just to kind of go through some of the basics. We'll send a follow-up email with Chris put together a really detailed presentation if you want to dig deep into this. But we're going to just touch on the state tax portion and the FERPTA portion and some other practical information. All yours, Chris.
All right, thanks, Andrew. So, as Andrew mentioned, I'm the trust and estates attorney for Chapes Pro. It's Luftig. I do regular domestic planning. It's kind of our bread and butter, but at the same time, also have a niche practice area with international clients. I've developed this practice over the last, I would say, 13 years or so. Before Chapes Pro, it's Luftig. I was in a boutique law firm that dealt really almost 90% of international clients. And one thing I noticed when working there is a sort of it's sort of a vacuum in terms of planning for foreign buyers when they come here, right? And why is it important to plan for foreign buyers? Why are we even having this discussion? Well, um, probably the biggest single issue that a foreign buyer is ever going to face when they're purchasing real estate, especially in places like here in New York, for instance, real estate costs are quite high. It's quite valuable, is the potential for what we call an estate tax. And estate tax, what is it? You guys probably heard it in the news. It's also colloquially known as the death tax, right? There's a federal estate slash death tax, and that goes up to 40% of fair market value of the assets that's transferred due to death. Now, there's also a complementary rule to that. It's called the gift tax. It's essentially the same tax, just gifts. Gift tax is for any gifts made during life. Estate tax is charged at death, right? That's what we call an estate because it's charged to the estate, right? So I'm going to get into that in a little bit more detail. But I got this presentation here. I'm not going to bore you guys just like reading off of it. It's just more of to give a guide right to this presentation. We'll be able to send this out to you guys, and of course, our door is open here for you. If you have any questions or concerns, feel free to reach out to us, right? Like Andrew said, for you guys, it's more like issue spotting. The rules are incredibly complex here, right? But one thing that is perhaps the most simple thing is what's classified as a U.S. person, right, for tax purposes, what's classified as a non-U.S. person, right? So, um, so there's three basic classifications here, right? You've got U.S. persons, you've got non-resident aliens, and you've got non-citizen domiciliaries, right? Now, U.S. persons, uh, two people that are U.S. persons are U.S. citizens. Okay, no matter where you are, if you hold a U.S. passport, you could have never lived in the United States your entire life. You're probably born to an American parent outside the United States. I get that a lot, actually. Still a U.S. taxpayer, still has to file income taxes, right? The same is true for green card holders. If green card holders, no matter where they live in the world, if they hold a green card, they are a U.S. taxpayer, right? Now, other types of U.S. persons, like a U.S. corporation, in certain situations, U.S. LLCs, and also any foreigner that spends a substantial amount of time in the United States, regardless of their immigration status, right? They could even be here undocumented. If they spend more than 183 days of physical presence, the U.S. they are a U.S. taxpayer, right? For at least for income tax purposes, right? Um, it's these tests are very difficult. There's something called a substantial presence test. You got to take all the days in one year, then a third in another year, then a six in the year before that. You got to add them all up. It's got to be 30 days in one year. Bottom line is that don't try to stress yourselves out over this because someone's tax status, especially if they're not a green card holder or a U.S. citizen, can be fluid, right? So always send them to someone like us or any other tax professional. Obviously, we would like to have that conversation. All right. But one thing that's clear is don't assume anything. All right. Don't assume anything. If someone has a social security number, for instance, don't assume they're a US citizen. Don't assume they're a green card holder, right? Social security numbers are for life. And someone could obtain a social security number when they're temporarily working in the US, then leave, and then use that social security number in the future. That doesn't really mean anything. Okay. Some people get very carried away. Other things as well is like LLCs. Don't assume that it's a U.S. person and so forth without speaking to a professional, right? Again, this is what we call issue spotting, right? So let's just discuss really fast, though. Why is there an issue with estate tax here in the United States? Well, as I had mentioned, the tax can be up to 40%. That's both gift and estate tax for a gift or a transfer at death. Now, you all might be wondering, well, if this is such a huge issue, do I have to plan for it? Right? I mean, we all live here, right? Well, the rules are a little bit different if you're either a US citizen or a non-citizen that's considered domiciled in the United States, right? If you are a US citizen or if you are a non-citizen domiciled in the United States, then you currently have an exemption of $14 million per person. What does that mean? That means your estate or your any gifts you make, you're only going to start paying that tax on the first dollar above $14 million, right? Now, if you're a couple, for instance, you could leave up to $28 million, right? It's per person, right? So, two spouses, one each has $14 million. They can leave to anyone other than the spouses up to that amount. So this does not affect, I would say, 99.9% of the population, which on one hand is great. On the other hand, it kind of leaves people a little caught off guard when we're dealing with non-citizens, non-domiciliaries, right? And why is that an issue? Well, because if you are a non-citizen, not considered domiciled in the United States, then the exemption amount is not $14 million. The exemption amount is only $60,000, right? So if they die or make a gift, for instance, a gift or they transfer at death, such like real estate, they hold here. They hold it either in their individual name, which is almost always a bad idea for foreign buyers. Then there is going to be a tax of up to 40% on any fair market value of $60,000. That is a substantial tax bill, and we have seen this happen. I have had to deal with it. And the frustrating part about it is if they put a plan together like Andrew mentioned, this can actually be avoided. I mean, it can be avoided to the extent that it's almost a voluntary tax, right? Um, with the kind of planning opportunities that we have. Now, um, I just want to touch briefly here on my presentation because I mentioned who qualifies for that $14 million exemption. One, like I said, US citizens. Two is US domiciliaries, right? What's a US domiciliary? That's a tough question to answer. It's really, really tough because it is a subjective criteria. What I mean by that is if you're for income tax purposes, income tax, the rules that I just mentioned, the substantial presence test and green card holders and US citizens, that's objective. It's like maths almost. We have a calculation here. We know for certain whether someone's considered an income tax resident of the United States. But for gift and estate tax purposes, it's a more of a nebulous concept, right? We have to kind of go into the mind of the person and see where they were considered domiciled at death. By the way, this also applies for green card holders. A lot of green card holders just assume they have that $14 million exemption from estate and gift taxes, which isn't necessarily the case, right? You could have a green card, for instance, be considered an income tax resident, but, and I've seen this happen before, people get green cards and then they decide, I'm not going to live in the US anymore, but I don't want to abandon the green card. I want to keep it. So I don't know, they go, I deal with a lot of Brazilian clients. So they go back to Brazil, they spend, I don't know, 10 years there, never having given up the green card, and they hold substantial property assets, especially real estate here, without realizing that if they die, they're not going to qualify for that estate and gift tax exemption, right? And that their exemption is only going to be $60,000. Now, it's important to mention that the it's important to mention that if you're considered a non-citizen, non-domiciled, although they only have this $60,000 exemption, they are only subject to US estate tax on what we consider the US situs asset. Basically, assets that under the Internal Revenue Code are considered as being located here in the United States. Now, that rule is very technical, but suffice to say, for all you real estate professionals, that interest includes real estate, includes co-op shares, it includes shares of like a U.S. corporation, and it potentially includes membership in a U.S. LLC, right? So it's not sufficient. I hear this so often. Oh, let's just throw it into a US LLC and it will just solve it. No, that's not going to solve it. We need a little bit of more robust planning there into order to really avoid this risk, right? So, now there's different types of strategies we utilize. Some of those strategies can vary wildly. Everything at the end of the day all depends on the client. There are attorneys, accountants out there that they say, you know, throw it into like an offshore company, for instance. And that's it's sort of like a one size fits all strategy, right? Um, that's not necessarily going to work for every single client. Every single client is different, right? Some things that we have to analyze of the clients when I have a conversation with them is number one, their immigration status. Number two, are they U.S. citizens? Number three, are they entitled to U.S. citizenship and they just don't know it, right? Number four, do they have kids that are U.S. citizens or are going to be U.S. citizens? Number five, what's the value of the real estate? Number six, is it for rental, investment, personal use, or is it for appreciation? Are they going to flip it soon? All those factor into how we determine what an appropriate plan is for that client, right? And the appropriate plan can vary wildly. It can be very, very complex. We can have multiple layers of different companies. We could have probably just an irrevocable trust. And then sometimes when things are, you know, sometimes it can be straightforward. I said before that for international buyers, it's rarely a good idea to purchase in their own individual name. Having said that, sometimes that makes more sense, perhaps with estates, with a real estate that has a lower value, for instance. The person's very young. They're probably going to sell it in the future, or they qualify for life insurance policies, for instance. So that could probably pay an estate tax. So In those situations, we try to keep it as simple as possible because every structure has some form of pros and cons, and you have to do a cost benefit analysis for each one. And the screen that you're seeing right now on the PowerPoint presentation sort of illustrates that. When we're dealing with putting together different structures for clients, I always have to analyze and do a balancing act and inform the client. You know, it's not just a simple matter of creating a structure and then forgetting about it, because those structures typically have costs involved. They have annual costs. They have to file tax returns. Here in New York State, if you own it in a corporate structure, whether it's foreign or domestic corporation, there's a corporation tax, minimum corporate franchise tax to pay for the privilege of that corporation doing business in the state of New York and employing capital here, even if it's not receiving any rental income. So that depends entirely on the fair market value of the real estate. So that's a conversation we need to have with the client, and it's better to have that conversation sooner than later. Why? Because another thing as well is when we're decreasing the estate tax bill, we tend to increase the income tax bill, right? There's no perfect solution, there's no silver bullet. It's there's sort of give and takes, and that's why the client has to be able to make an informed analysis. Okay? Now, I'm just going to go over a couple of what kind of holding structures are there then that we tend to employ in order to avoid these sort of estate tax issues, gift tax issues, etc. And they also tend to avoid FERPTA withholding as well that Andrew mentioned, which I'll go on into a little bit more detail um, at the end of the presentation. Well, the most common holding structures we have is um, what I call the double corporate structure. Double corporate structure is basically we create an offshore company, right? The client then is the shareholder of this offshore company. They're in full control over it. Then they either purchase the real estate directly in the name of the offshore company, or we put an additional layer, for instance, a New York corporation that's wholly owned by the foreign corporation.
Wait,
Now,
Alex, I think was that I don't know if Chris, I don't know if that was you or me that just I think we lost you for a second. Might have been me, but just repeat what you said.
oh, sure. Yeah. So one of the common holding structures we have is a corporate structure, right? So it has generally speaking, these have two different layers. We have an offshore entity the client fully controls, they fully own it. It's in a low tax jurisdiction. And then typically that owns, like, for instance, a New York corporation. And then it's the New York corporation that purchases the real estate. That's the more common one for very high net worth clients, for those that, we're talking about real estate and several millions of dollars and so forth. That avoids the estate tax. Why? Because if the client passes away, they are holding shares of an offshore corporation. They're not holding the real estate directly. They're not holding the shares of a US corporation directly. So that avoids an estate tax. And then typically we slap on a trust there to avoid any sort of probate proceeding on those shares. And at the end of the day, what you do have? You have a very robust structure that basically protects against the US estate tax risk. They can also even gift shares to their kids without having any gift taxes because the gifting of shares of a foreign corporation is outside the taxing jurisdiction of the United States, right? Now, there are some other structures. I typically do this post sale. And when they come to me after a purchase, maybe not as robust, but still allows some level of protection. We call them a double partnership structure, domestic partnership owned by foreign partnership, and so forth, which isn't quite as robust as the one that I just mentioned, but it does give an added layer of protection, right? Now, one thing that's very, very important is to this planning has to be done ahead of time, well ahead of time, preferably even when they're still looking at real estate. It's good to have this conversation. Uh, we tend to have this conversation most often when they've already found the property and they're already looking to make an offer. or they've made an offer and now we have to go to contract. So they, typically Andrew gets that phone call, him and his team, and then, we do a little triage here, office, which is, hey, are you a foreigner? And so if they're a foreigner, then he says, I think you should have a discussion with Chris. It's not a problem at all. We do that all the time, right? Um, but it's important that they have that conversation with us. Oh, and if not even me, then their own tax. If they even have sometimes they have their own tax professional, but it's important that they have this conversation, uh, just so that they're aware of the potential risks and the potential opportunities. And it's not just a simple matter of trying to plan in place, as soon as possible for the closing, but it's also because what happens after they receive the deed is that the planning opportunities become very, very limited, right? Those FERPTA rules that we mentioned in terms of the 15% withholding that some of you might be familiar with, well, those also apply for any potential reorganization of real estate that is already owned by the foreign client. If I, for instance, if they purchase it and then they come to me and they say, oh my God, it's in my own individual name, but I actually want to transfer it to my offshore company, for instance, that's really difficult. That's going to be really tough. There's going to be realization of gain. There's going to be a phantom sale to the foreign corporation. There's going to be withholding, and you need to get IRS permission. And it's generally speaking, post closing, that's not a viable structure anymore. Um, and then I have to consider other different structures in order to mitigate the impact, right? And and it's not only FERPTA applies, but they also will have issues. So they try to gift it, for instance, right? There's going to be a potential for gift tax if they own it directly in their name. Maybe they want to add like a son or daughter onto the deed, for instance, right? They always have to have these conversations with the tax professionals, such as myself, before doing any of these kind of restructurings. Um, so having said that, you know, I'm going to go into FERPTA rules in just a minute, but I'll give you a sort of experience of that I had when I was a relatively young attorney. One of my first clients was a famous Brazilian actress who I shall not name. But she had purchased some real estate here in New York City. She was not a resident here in the United States. She was a resident in Brazil. And she purchased it before she met me and my office team. And I think it was for about 2.5 million that she purchased it for, something along those lines, and she had purchased it in her own individual name. So, uh, when she came to us, she was just initially looking for some succession planning, right? Avoid probate avoidance, things like that, a potential will, a potential trust. And then we told her, this is probably a year after the purchase, we told her, um, do you realize that if you pass away, there's going to be an estate tax of perhaps about six to $700,000 on the real estate? And she looked at us shocked. She was like, "How really? How come I've never heard of this?" Like, yeah, it's there's going to be an estate tax. And not only that, but if you die, that estate tax has to be paid within 9 months of death. The IRS doesn't wait around for their money. So she was quite taken aback by that. And what I mean by the 9 months is, especially if the estate, for instance, doesn't have liquidity, and that's usually the case, right? Things get tied up, things go outside of probate and so forth. The only alternative will be to do a fire sale of the apartment in order to get the funds necessary to pay the IRS estate tax, which could lower the value of the potential value of the real estate, right? So it's sort of like a insult added to the injury in that situation. So she looks at me. She's like, she seemed kind of stunned. She was like, but I had brokers. I had like really great brokers helping me. I had an attorney helping me. Like, why didn't anyone mention this to me? She was quite upset. And the fact is, um, we all have our specializations, and this is a bit of a niche practice area. Most attorneys aren't aware of these risks. So most accountants aren't aware of these risks. And a lot of brokers also aren't aware of these risks, right? So she was quite mad at that, but we managed to get her put into a structure. We had to recognize gain. We had to pay tax because she was like, "Oh, I'm never selling this property. I'm going to keep this forever. I absolutely love it." So we went through the whole rigmarole of restructuring, and then what ends up happening is a year after that, she ends up selling the property. So, and she actually lost some money in taxes too. So,
Yeah, and just
the
to Chris's point, it's all friendly competition. We make it a point to be very friendly with the other attorneys. And just before Chris was around, we would refer it to, it was typically corporate firms. And the problem with corporate firms is they don't know the cadence of real estate deals. They don't know that things have to get done in a day or two, or maybe if you're proactive, a week or two, not a month or two. So it's just a different, speed. We all know that. And you kind of lose control. And um, most attorneys, we didn't have this in-house. I'd referred out, and then if we weren't really lined up way ahead of time, it derailed the deal. Clients would get nervous. So Chris has gotten better. I joke around when estate planning attorneys don't respond to emails and phone calls within minutes. Most lawyers don't. Real estate lawyers are trained to do so. But Chris is, fast, not as fast as we'd like because he actually has to sit there and read through his consultations are hours, not 15, 20 minutes. So I joke around, but it's he understands the cadence and he does the best he can. Why don't we jump to FERPTA, Chris? We have about 10 minutes,
yeah,
10 minutes, give or take, left.
yeah, absolutely, yeah. And
We
just
do
to
have
let
some
you guys know,
questions.
just
Does it make a
okay.
difference if foreigner owns acquire a visa and starts working in the States while owning the property?
It's from Mark. Yeah, Mark, absolutely.
Yeah.
Yeah, it can. It can, Mark. It really depends. For income tax purposes and FERPA avoidance, I'll get into that in a second. It can definitely make a difference. In terms of estate and gift taxes, yeah, potentially, yes. Having said that, a key rule here is a lot of people come here, for instance, on H-1B visas. These are what we call non-immigrant visas, which means they're temporary. They're not intended to be permanent. And so by default, if someone is here on a non-immigrant visa, they are not domiciled here because they've already made they've already made affirmation to the U.S. government that they're going to return home and their stay here is only temporary, right? So they still have a gift and a potential gift and estate tax issue if, for instance, they decide to own the property in their own name. Having said that, everything depends, right? The person that's on an H-1B visa here today could be turn that H-1B visa into a green card and then stay here forever and then stay as a citizen and then change that to citizenship. And then they don't have an issue, right? So everything entirely depends on the fact pattern, right? Um, Maggie, what about gifting cash prior to purchasing the real estate in a foreign country first? They actually apply yet. Um, Parents buying for children scenario. Maggie, yeah, absolutely. And that can work. That can work. And that's something, especially the situation you bring up. I've actually had a couple of conversations fairly recently where a child of substantially wealthy parents, they have a lot of money. They want to buy the child the property. They're just better than renting, right? Child's young. So one thing that the parents do is now something that we also assist the clients on is how to make those gifts, right? And I think you might have a little knowledge here, because you're absolutely right on the ball there. If a cash gift is made outside of the United States, between foreign to foreign bank account. That is a completed gift outside the United States, assuming the parents are non-citizens, not green card holders, not domiciled here, and it's free of U.S. gift tax issues, right? Um, Having said that, I'm not going to get into it. There's this whole doctrine under tax law called the step transaction doctrine. It just like if they end up buying it, there was an implied intent for them to buy U.S. real estate. In theory, the IRS can claim that it was really a gift of a U.S. situs asset. That's very, very rare. That's a very, very rare challenge. But we always have to analyze the risks vis-a-vis what the specific client and their objectives. So let's just get into these FERPTA rules really fast because we really we get a lot of questions about FERPTA, right? And so Andrew already kind of gave a bit of a background about it, but I'll just recap very, very briefly. What is FERPTA? You guys might have seen this already if you've dealt with a foreign seller before. Um, And FERPTA is basically, like Andrew mentioned, it's a withholding mechanism, right? Let's say, for instance, you're a foreign person and you're selling your US real estate. You did very well. That foreign person did very well. They have a lot of gains, right? Well, when they sell the real estate, they have to pay US income tax on the capital gains, right? On the net capital gains. Now, the IRS is concerned that, well, what happens if what happens if that foreign person takes the money at closing, transfers it to their home country's account, which they usually do, and then they never file a tax return, never pay the income tax. We're never going to see that income tax, right? It's too hard. In theory, the IRS can chase after them. In practice, they don't want to do that. So what do they do? Well, FERPTA is a mechanism to ensure that they pay their income tax bill. And that basically means that when you have a foreign seller, the buyer is obligated to withhold 15% of the entire sale price or purchase price. And so if it's $1 million purchase price, the withholding is $150,000. That has to be sent to the IRS within 20 days of closing. Regardless of the gain or loss. That's a very common question. We have, oh, what happens if the foreign seller, oh, but I'm realizing a loss on this. I'm actually selling it for less than I purchased it for. It doesn't matter. The 15% still has to be sent to the IRS. Now, that does it, like Andrew said, it's not a tax in of itself. It's a withholding mechanism. Essentially, the IRS is holding that 15% hostage and saying, hey, we have your 15% here. If you made a loss or that isn't the tax that you owed, file a non-resident tax return the following year and claim a refund on the difference or the entire amount, right? So they have to file the income tax return. The IRS reviews it, has the opportunity to review it, and then if they're satisfied of it, they release the funds back to the client, right? And it can be a very frustrating situation. Just because depending on the time, it can take quite a while to get that back. Let's say, for instance, we sell the property today. What's today? March 27th, right? When will they have an opportunity to get that money back and request that money back? They're not going to have that opportunity until the IRS starts accepting tax returns for the calendar year 2025. That's probably around late January, February 2026. So they're just going to have to wait until they file that tax return, and they're going to have to wait for the refund check to come to them, right? So they could be looking at over a year before they can get, if they were to sell it today, to get that refund, right? So it can be very frustrating. Now there is a mechanism that I'll go into. It's called a certificate of withholding. It's basically asking the IRS permission to lower the withholding. And before the pandemic, there were opportunities to utilize that, and I utilized that to great advantage, and it worked very well. We would hold the funds post-closing until we got a response from the IRS. IRS would respond in like 90 to 120 days saying, hey, okay, here you go, buyer. Here's a certificate. You only have to withhold X amount, right? And then the buyer's attorney would release the funds. Since the pandemic, the team that runs the FERPTA office out of Ogden, Utah, have been decimated. It's taking a year to get any sort of response to them. We just don't do them. And I just found out, actually, I just read a news report that the Ogden office literally lost all of their probationary employees. Things were improving last year, and it's not going to get better anytime soon. They literally just fired like a ton of people there. So unfortunately, that's not an option. They have to file an income tax return the following year to get that money back. Right. So there are certain exceptions to the FERPTA withholding. It's a non-foreign affidavit, non-foreign affidavit. It only applies to the seller as a U.S. person. The concept of U.S. person can be tricky. Suffice to say, if the person is a green card holder or a U.S. citizen, no matter where they live, they are a U.S. person, so they are exempt from FERPTA. Okay, it's a very easy rule in that respect. U.S. citizens, green card holders, not subject to FERPTA. Doesn't matter where they live. If they don't have a green card, if they don't have a U.S. citizenship, then it gets tricky. Then we have to presume there's going to be FERPTA, right? And we have to do a bit more of analysis to see, okay, well, what's their situation? Are they on a non-immigrant visa? Do they have a visitor visa? How much time do they spend in the United States? How much time do they plan to spend this year? and so forth, right? It could be, for instance, that it's an entity that's selling it, right? An entity like a foreign corporation that's subject to FIRPTA. It's a foreign entity, right? What about an LLC, for instance? We get a lot of LLCs. A lot of people say, oh, LLCs is not subject to FIRPTA because it's a US entity. Not entirely true. If the US LLC only has one foreign member, it's disregarded and it's taxed directly to that foreign member. And so FIRPTA applies. If there are, for instance, more than one member in an LLC, then FIRPTA doesn't apply, even if all the members are foreign persons. So that's a planning opportunity we sometimes use to avoid FIRPTA. But and just to mention, by the way, I get a lot of questions. What happens if it's 1031 exchange? Can we avoid FIRPTA? No. All right. If FIRPTA 1031 exchange does not allow FIRPTA avoidance, right? It still has to be done. But how is it that we tend to avoid FIRPTA? Well, if I'm creating a structure for a client, first of all, we always mention FIRPTA to them, number one. Number two, we our structures tend to avoid FIRPTA. That's one of the reasons why, for instance, I put a New York corporation on top of like a BVI company, is because the New York corporation is a U.S. person. Doesn't matter if the sole shareholder is the ultimate beneficial and is foreign. That's a U.S. person. FIRPTA is exempt. Throw it into an LLC. Husband 100% is the owner and he has a wife, throw 1% to the wife, right? Now you don't have FIRPTA, right? So there are planning opportunities, but the key here is it has to be done ahead of time. We can't do this kind of planning of FIRPTA avoidance on the day of closing because it's just first of all, if it's just merely for the fact to avoid FIRPTA, then the buyer's attorney can challenge it, the IRS can challenge it, and so forth. Right. Um, so a couple of things as well is um one of the other exceptions, it doesn't really apply in New York. I'll just mention it briefly because there's certain low value exceptions if the property is being sold for $300,000 or less. Um, there's the potential to avoid FIRPTA, but the buyer has to certify that they're going to use it as their primary domicile for the next 2 years after buying, essentially. And a lot of buyers just don't want to take that risk. They're just like, I don't want to certify anything. Just it's not my problem. I'm just going to send the 15% withholding. I'm not going to get into that too much. We really don't see property of that kind of value for sale, at least here in New York City. Um, the certificate of withholding application, this is something I mentioned, which is just basically asking the IRS for permission. You might hear about this, right? You might hear about this from other sources. Um, in theory, the IRS pre-pandemic took 90 days to respond. It was great, but now it's a mess. We don't do it. I did try to do it last year and the year before that. I gave the clients abundant notice, like, hey, look, this might be just a waste of money. I don't know how long it's taking to process. I just don't recommend it. I don't recommend it these days, unfortunately, and for the foreseeable future. We actually did have a client who came to us, and he got some bad information from a tax advisor who wasn't aware of things, and that turned into an issue because he gave the client false hope that he wasn't going to have a big FIRPTA withholding. In the end, that's exactly what had to happen. Um, so, just keep that in mind. Um, we always have this conversation if we have a foreign seller that we're representing, right, Andrew? We always have that conversation about FIRPTA withholding and also New York State non-resident withholding, which isn't quite as harsh as FIRPTA. It's only on the net gain and it's at the 10%, the
Yeah,
10.9%,
yeah, it's a
But we
hard
do have,
conver
yeah, sorry,
sorry,
go ahead.
sorry. It's a hard conversation when it's a surprise. Um, but there's unfortunately no way around it. And we have to also be very careful. If it's not handled properly, the interest and penalties are absurd. And a lot of
Yeah.
time you're mailing snail mail. So it's a very sophisticated technical area. A lot of attorneys don't even want to get involved because of the exposure. But just to kind of wrap up, we'll send a presentation. Certainly, let us know if you have questions. Some quick practical considerations like closing costs, or the closing costs for even domestic clients are a surprise. International clients, it can like knock them off their chair. So talk to them about closing costs ahead of time. You know, I'm gonna steal Chris's thunder just to wrap up, but holding the client's hand, like insurance, they don't know about insurance, about cable, about setting this stuff up ahead of time. I do find, and you may know better than me, I don't want to, step on shoes, but I find a lot of international clients love to buy properties near New York City landmarks, you know, because they can almost boast to their friends and family that, oh, I own an apartment near the Empire State Building. Most of our domestic clients don't want to be anywhere near the Empire State Building. When the Satai, first came around, it was all international clients, or even now like Hudson Yards, right? Obviously, Billionaires Row, but now Brooklyn has become an international destination. So, um, the idea with any deal is to be proactive, but with international clients, you have to be incredibly proactive. And, whether it's us or another firm, get somebody involved because we're going to discuss topics that you won't, and we'll protect you, and the
Yeah.
client, obviously.
And if I could just make one more last comment, Andrew, that sorry if you already touched on this, but privacy. Now you might
Right.
have clients. I might have a conversation with a client, and they're fully informed. They know the risks of estate and gift tax. They're like, I don't care. I'm gonna be dead. What do I care about it? Let my heirs deal with it, which is fine as long as they make an informed decision.
Thank
However,
you.
one thing that a lot of foreign clients don't realize is how public deeds are here in the United States, right? It's very public. You can easily search it. You can here in New York City, you can just go into Acris, type a name, hit even Google it, and immediately the deed will appear. Now, this is very off-putting for a lot of foreign clients in my experience, because in a lot of countries, deeds for real estate aren't as public as this. They're almost private, almost like tax returns, right? So sometimes that catches them off guard. I have had situations before when clients buy the real estate, they want anonymity, probably because of, high risk of, I don't know, kidnapping in their home country, and so forth. They don't want people knowing that they directly own, like, a $5 million apartment in New York City. And the issue is, of course, once they buy it in their own individual name, that record is there forever until the end of time. I've had clients come to me as like, oh, please, 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 can you help me remove my name? I was like, I can't do it. It's in the chain of title now. So even if they don't so much care about the risk of U.S. estate and gift taxes, they might care about their name being in the public records, right? And so that might be a reason to create a structure, maybe a trust, maybe an LLC, and so forth, right? So just keep that in mind as well. So with that said, it's 10:50. I'm just see if there's any additional questions. If not, we can wrap it up. Ronit, oh, thank you, Ronit. Thank you for the kind words. I very much appreciate that. And um, any questions? If you have any questions after the presentation, please do feel free to reach out to me. All right. I'm available by email. Give me a phone call as well. I'm usually best reached by email, and I'll do my best to help you guys. Any questions you may have, we're happy to help out you real estate professionals. Okay. Thank you so much, everyone. That concludes our presentation. And until the next one. All right. Take care, everyone.
Take care. Thank you. Sorry.